With that, Mr. Chairman, I yield back, and I thank the witnesses again for being here.
Thank the gentleman. The prime witness that we had invited, Mr. Rhodes, from the White House, has declined to come before the committee. We're disappointed in his failure to appear. Chair also notes that contingent upon Mr. Rhodes appearing, an invitation to appear was extended to the Honorable Tom Cotton, United States Senator from the state of Arkansas. This was done at a request of the White House. Given that Mr. Rhodes had refused to appear before the committee today, the distinguished senator from Arkansas is also excused.
Mr. Chairman.
Yes, gentleman from South Carolina.
I have an inquiry.
Yes.
Is Mr. Hanna here?
Yes.
Well, then why didn't Mr. Cummings ask him the questions? He'll have a chance to ask Mr. Hanna whatever questions he wants to ask him. We don't have a chance to ask Mr. Rhodes the questions we want to ask because he didn't bother to show up. Mr. Hanna did.
But Chairman Yield,
yes.
I can say whatever I want to say in my opening statement.
Yes, you can. It just needs to be fair. That's my point. Just be fair about it. You can say what you want.
Gentlemen will state his inquiry.
I just want to know if he was here.
He's here.
Tell me he is.
Take the gentleman.
Okay.
And Mr. Rhodes is not here. I would also note that the Democrats were free and usually, almost always, in my experience, invite a Democratic witness. But there is no Democratic witness today because you didn't invite one.
Chairman Yield.
Sure.
Chairman, you know for a fact that we got less than the notice that's required in the rules. We did not object and went on with the hearing. You know that.
I disagree with the timing issue that you suggest.
You gave us the required time?
Yes.
I disagree with you.
Okay. We'll sort that out. We have a good working relationship, Mr. Cummings and I. But
Parliamentary inquiry.
The gentleman from South Carolina.
Does the executive privilege apply to media interviews or only to appearances before Congress?
I don't know the full answer to that, but I believe they're free to talk to whoever they want to in the media, but they did claim in Mr. Eggleston's letter to claim executive privilege.
So is that a yes or a no? Does it apply when you're being interviewed by the New York Times or ABC or CBS, or just when members of Congress want to ask questions?
Evidently when members of Congress.
I thank the chairman for that clarification.
The invitation to appear was extended to the Honorable Tom Cotton, United States Senator from the state of Arkansas. This was done at a request of the White House. Given that Mr. Rhodes had refused to appear before the committee today, the distinguished senator from Arkansas is also excused.
Mr. Chairman.
Yes, gentleman from South Carolina.
I have an inquiry.
Yes.
Is Mr. Hanna here?
Yes.
Well, then why did
With that, Mr. Chairman, I yield back, and I thank the witnesses again for being here.
Thank the gentleman. The prime witness that we had invited, Mr. Rhodes, from the White House, has declined to come before the committee. We're disappointed in his failure to appear. Chair also notes that contingent upon Mr. Rhodes appearing, an invitation. I disagree with the timing issue that you suggest.
You gave us the required time?
Yes.
I disagree with you.
Okay. We'll sort that out. We have a good working relationship, Mr. Cummings and I. But
parliamentary inquiry.
The gentleman from South Carolina.
Does the executive privilege apply to media interviews or only to appearances before Congress?
I don't know the full answer to that.
Let Mr. Cummings ask him the questions. He'll have a chance to ask Mr. Hanna whatever questions he wants to ask him. We don't have a chance to ask Mr. Rhodes the questions we want to ask because he didn't bother to show up. Mr. Hanna did.
But Chairman Yield,
yes.
I can say whatever I want to say in my opening statement.
Yes, you can. It just needs to be fair. That's my point. Just be fair about it. You can say what you want.
Gentlemen will state his inquiry.
I just want to know if he was here.
He's here.
Tell me he is.
Take the gentleman.
Okay.
And Mr. Rhodes is not here. I would also note that the Democrats were free and usually, almost always, in my experience, invite a Democratic witness. But there is no Democratic witness today because you didn't invite one.
Chairman Yield.
Sure.
Chairman, you know for a fact that we got less than the notice that's required in the rules. We did not object and went on with the hearing. You know that.
Thank you, Mr. Speaker. I want to talk for just a moment as colleagues, not as Republicans or Democrats, not as members of the majority or the minority, colleagues who are blessed to serve in the United States House of Representatives, the People's House, with all the tradition, with all the history, with all the laws that have been passed, with all the lives that have been impacted. I want us to talk as colleagues, because our foundational document gave us, as the House, unique powers and responsibilities. We run every 2 years because they intended for us to be closest to the people. The President was given different duties and powers. The President was given the duty to take care that the laws be faithfully executed. So my question, Mr. Speaker, is what does that mean to you, that the laws be faithfully executed? We know the President can veto a bill for any reason or no reason. We know the President can refuse to defend the constitutionality of a statute, even one that he signs into law. We know the President can issue pardons for violations of the very laws that we pass. And we know that the President has prosecutorial discretion as evidenced and used through his U.S. attorneys. Mr. Speaker, that is a lot of power. What are we to do when that amount of power is not enough? What are we to do when this president or any president decides to selectively enforce a portion of a law and ignore other portions of that law? What do we do, Mr. Speaker, regardless of motivation, when a president nullifies our vote by failing to faithfully execute the law? How do we explain waivers and exemptions and delays in a bill passed by Congress and affirmed by the United States Supreme Court? How do we explain away a refusal to enforce mandatory minimums that were passed by Congress and affirmed by the Supreme Court? And why pursue, Mr. Speaker, immigration reform if presidents can turn off the very provisions that we pass? You know, in the oath that brand new citizens take, it contains 6 different references to the law. If it's good enough for us to ask brand new citizens to affirm their devotion to the law, is it too much to ask that the President do the same? If a president can change some laws, can he change all laws? Can he change election laws? Can he change discrimination laws? Are there any laws under your theory that he actually has to enforce? What is our recourse, Mr. Speaker? What is our remedy? Some would argue the framers gave us the power of the purse and the power of impeachment, but, Mr. Speaker, those are punishments. Those are not remedies. What is the remedy if we want the executive to enforce our work? This bill simply gives us standing when our votes are nullified. This bill allows us to petition the judicial branch for an order requiring the executive branch to faithfully execute the law. Mr. Speaker, we are not held in high public esteem right now. Maybe members of Congress would be respected more if we respected ourselves enough to require that when we pass something, it be treated as law. Maybe we would be more respected if we had a firmly rooted expectation that when we pass something as law, it be treated as law. Maybe we would be more respected if we put down party labels and to keep or retain or acquire gavels and picked up the history, the tradition, and the honor of this, the People's House. Mr. Speaker, the House of Representatives does not exist to pass suggestions. We do not exist to pass ideas. We make law. And while you are free to stand and clap when any president comes into this hallowed chamber and promises to do it with or without you, I will never stand and clap when any president, no matter whether he's your party or mine, promises to make us a constitutional anomaly and an afterthought. We make law. thank the gentleman from Utah. Mr. Chairman, you have an absolute right to remain silent. No inference or suggestion of guilt may be inferred from your invocation of that right to remain silent. However, if you do testify or take the stand, you will be treated like any other witness and subject to cross-examination. Mr. Chairman, the reason that that phrase is running through my mind is because I heard it for 16 years. It's being repeated in courtrooms all across this country today, but not for powerful people that work for government, just for everyday folks. Just for everyday witnesses or everyday defendants of petty crimes, not charged with violation of constitutional rights, maybe just petty larceny. But they're being told you have a right to remain silent. However, if you testify or take the stand, you will be treated like every other witness. Mr. Chairman, I counted 17 separate factual assertions by Ms. Lerner, not those 3 little sentences that my colleagues like to cite, 17 separate factual assertions. That is a lot of talking for somebody who wants to remain silent. That's a lot of talking. If you honestly believe that you can make 17 separate factual assertions and still invoke your right to remain silent, then please tell me what waiver is. Please tell me what constitutes waiver if saying 17 separate factual things does not. Mr. Chairman, she testified, I have done nothing wrong, I've broken no laws, I've broken no IRS rules or regulations. That's her testimony. What I'm saying is we should have the right to cross-examine her on that testimony. Because I'd like to ask her, when you said we need a plan, who is we and what plan are you referring to? When she said we need to be careful that it's not perceived as political, who is we and what are you concerned about the perception of politics for? What are you fearful of, Ms. Lerner? She said, I think we really need to do a project. Again, Ms. Lerner, who is we and what project are you referring to? That is a legitimate question. And every brother and sister at the bar on the other side of the aisle would ask that question on cross-examination if given the opportunity. Can you imagine, Mr. Chairman, can you imagine a fact pattern where somebody takes the stand and says, I didn't rob the bank? But I'm not going to answer why my fingerprints are on the demand note. And I'm not going to tell you why I'm on the surveillance footage with a gun in my hand. And I'm not going to tell you why the dye pack blew up in my car. I'm just going to tell you I didn't rob the bank. That's not the way our system works. You have to answer the other side's questions. I think these questions are fair. The Tea Party's very dangerous. Dangerous to whom? Who, Miss Lerner? Who thinks they're dangerous? You? The IRS? Dangerous in what way? We need a vehicle to get back to court. Who is we? Why do you want to get back to court? Could it, heaven forbid, be because you don't like Citizens United? Is that possibly the explanation? Mr. Chairman, she said Cincinnati should not have these cases, but then she turned around and said Cincinnati was to blame. That's an inconsistent statement. Every lawyer on that side of the aisle would ask her to explain that inconsistency. Everyone. So why can't we? If this isn't waiver, then can someone explain to me on the other side what fact pattern constitutes waiver? If you can make 17 separate factual assertions and authenticate a document, and say, I have done nothing wrong, which is about as broad as any testimony can possibly get. I've done nothing wrong. I've broken no laws. I've broken no rules or regulations. I mean, honestly, what testimony could be broader than that? So necessarily, our cross-examination should be equally broad, and it would be in a courtroom. How often did you use your personal email, Ms. Lerner? That's a fair question. The Committee on Ways and Means just referred that issue to the Department of Justice. How many times did you use your personal email? When you mused about applying for a job with an organization connected with the president, were you kidding, Ms. Lerner? Or were you serious? Oh, we know you were contemplating retirement. Were you really seriously going to work? Mr. Chairman, I know my time is up. I'm just going to say this in conclusion. The same Constitution that allows her the right, if she wants to sit there and say nothing, allows these groups the right to petition their government for redress.
I appreciate the gentleman. Gentleman's time has expired.